Hey, beautiful people. Welcome back. Your rights. Do you really know your rights? The 8th Amendment. Cruel and unusual punishment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Similar verbiage like this will be on the state level, regardless of what state, and oftentimes regardless of what year that state constitution is. So most of these verbiage within the Constitution, the reason why most people fail to bring the claim is because they don't know what these words and terminologies mean. In the past, we've went over the 4th Amendment regarding probable cause. What probable cause mean? Because within this document that gives private right of action called the Bill of Rights, the definition of the terms that's used are not defined. It gives commandments. It tells you this shall be done and this shall not be done. But these commandments do not define what these words mean. Hence, the loose term where you will hear people say common law is judge-made law, because the definition of what the verbiage within the commandment speaks of is interpreted and defined by either the legislature when certain legislative laws are made in harmony with these commandments, or by the judicial department through stare decisis. You see how all of that links together. So now there are several flaws in people's state of mind, not in the bodies of laws or the subsidiary entities that act in harmony with it, or at least are supposed to act in harmony with it. The true flaws exist in the people that say they themselves have the right. The first flaw is the people who quote these things and know that there's a significance in this do not know what the words mean. They do not know the significance of the words that they are regurgitating. The second flaw is many people don't even think they're supposed to be using this. To the second group of people who have that state of mind, good for you. See how far that takes you. To the other group of people who intend to actually use this, but are not using it properly, and thus fail to state a claim upon which relief can be granted, the flaw lies in what the words mean. In the past, we've went over what probable cause mean and the standards and the tests behind it and how it's tied into Terry stop and reasonable expectation of whether a crime has been committed, is being committed, or is about to be. Which, believe it or not, most municipal police employees do not know this either. They know the buzzwords, but they don't know this. So that puts them in the same boat as most people who talk about am I being detained? Is there reasonable suspicion? And so they don't care and they act arbitrarily. Know what these words mean. That would assist you navigate. In this specific instant, what does cruel and unusual punishment mean? Because clearly the commandments tells you cruel and unusual punishment shall not be inflicted. The determination of what certain things mean is based on tests. For instance, in the past regarding trust, how your trust is pierced, regarding control test and court test. That was went over about 8 months ago. And in the past regarding respondent superior, making their superior liable, or making the entity merge with the liability of the actors. There are tests to that. And those tests are called the benefit test and the characteristic test. When it comes to piercing the corporate veil, there are tests to that, meaning how you begin to really personally and privately hold people liable because they use the prestige and the pretense of a corporate entity or a body politic to engage in certain act, which most people loosely know as acting under color of law or color of authority. But that is just a verbiage. There's a dynamic and a doctrine to that verbiage, and there's a test to qualify that verbiage. And it's called a disjunctive test and a conjunctive test. And those two disjunctive and conjunctive tests are tied into the types of fraud. A lot of people say they're fraud, they're bad, they're fraud, but there are different types of fraud. And there are factors, 7 separate factors that must be proven in order for your claim of fraud to suffice. So all these terminologies are insufficient by themselves if you don't know what it is. If one is getting emotionally stimulated and being impulsive about this and that, you deep down know something wrong was done. But if you don't know the dynamics of it, you can never function with it. You would use these words on a piece of paper and the court would end up dismissing your case. Then you're going to be going around saying it's their court, they're fraud, they don't have jurisdiction because this and that. You yourself did not know what these things mean. Hence, the other people on the other end, who are the tortfeasors, get more comfortable because a bully only gets more comfortable in what he or she does when he or she is well assured that the one being bullied does not know what he or she needs to do in order to get away from being bullied. When it all comes down to it, that's what the majority of people in today's world are dealing with. They're being bullied. They're being bullied because they don't know. Some people either don't even explore it by saying this thing doesn't work. Some explore it without intuition, wisdom, and knowledge. And they just throw words around and expect somebody to act without them themselves taking self-responsibility of knowing what's been spoken of. And when they get thrown out, they say it doesn't work or they get upset. You be that exception. There's a test regarding what qualifies as cruel and unusual punishment. These tests exist in order to afford due process. The self-execution of constitutions exists if there are no legislature that act as a vehicle to enforce them. The self-execution of these constitutions exists where the remedies is not clearly stated in its face, like an injunctive relief. The self-execution of these private right of action within the Constitution exists where you know the dynamics of what these words actually mean. If you don't, you can scream out of your lungs all day long that the Constitution is self-executed, that they can't do this or they can't do that, or they don't have jurisdiction. All that will be done to no avail. Competency is the key. And here it is. Everything that's going to be shown today is based on rule of evidence 902 and 903, self-authenticating evidence and official publications. This is from the Library of Congress, their digital library, something that you can go and look into, something that you ought to be looking into. The Library of Congress is a collection of decisions, memorandums, international and national laws that the legislative department of government, the legislative meaning they make the law, that they deliberately pull out there for you. You have access to these things. But to save you the time and effort of doing the deep research, here it is right here. In the age of technology, there's no excuse for anyone to complain about not having enough information because it is out here in abundance. What does cruel and unusual punishment mean, and what does it stand for? It's defined within the case law Furman versus Georgia in the year 1972 through the Supreme Court via certiorari. Certiorari is just another word for Supreme Court level of appeal, not just a regular appeal, meaning appeal of an appeal in a way. Case number 69-5003. According to information provided by Library of Congress, disseminated through the medium called the U.S. Report, which is basically the entity that published the official case books and opinions of Supreme Court of the United States. So what is cruel and unusual punishment? Within this case law, the memorandum, it is on page 45. Since the Bill of Rights was adopted, this court has adjudged only 3 punishments to be within the prohibition of the clause. Specific clause here is cruel and unusual punishment clause. Each punishment, of course, was degrading to human dignity, but of none could it be said conclusively that it was fatally offensive under one or the other of the principles. Rather, these cruel and unusual punishments seriously implicated several of the principles, and it was the application of the principles in combination that supported the judgment. That indeed is not surprising. The function of these principles, after all, is simply to provide means by which a court can determine whether a challenged punishment comports with human dignity. They're telling you their foundational principles to which these words written down as commandments stand on. And if you do not know these foundational principles, you cannot state a claim, because the foundational principles is what they're looking at. That is the lens that they're using to interpret your words, outside of how you feel about what was done to you, outside about how you feel about a group of people, outside about how you feel about who has power and who doesn't. Deal with foundational principles. Stop using buzzwords. And the foundational principle behind what qualify as cruel and unusual punishment, the specific phrase within the 8th Amendment: no cruel, unusual punishment shall be inflicted. Excessive bail shall not be required, nor excessive fine imposed, nor cruel and unusual punishment inflicted. This term cruel and unusual punishment, what does it mean? And what is the foundational principle behind its meaning? Simple: human dignity. And then it goes on to give you 4 qualifying factors of what this human dignity means. They are, therefore, interrelated, and in most cases, it will be their convergence that will justify the conclusion that a punishment is cruel and unusual. Meaning these factors that are about to be spoken of are all interrelated, and they qualify what this term means. Meaning if you go into any court and you're saying you've been inflicted cruel and unusual punishment, and you're not listing these things and showing how it relates to your specific circumstance, your cause of action, you're not stating any claim upon which relief can be granted. The test, remember we spoke about several tests to qualify certain terminologies. The test then will ordinarily be cumulative 1, meaning not one or the other, meaning there are several factors and all of them must be applied or applicable in your circumstance. If a punishment is unusually severe, if there is a strong probability that it is inflicted arbitrarily, if it is substantially rejected by contemporary society, and if there is no reason to believe that it serves any penal purpose more effectively than some less severe punishment, then the continued infliction of that punishment violates the commandment clause of the states that the state may not inflict inhumane and uncivilized punishment upon those convicted of crimes. They let you know these Bill of Rights are commandments. So when I say that these are commandments, those are not just empty loose words. The way that this spiritual document called the Bill of Rights was put together is not a coincidence that 10 of them are called Bill of Rights and everything else after is something else, because these are the commandments. Many people who use these documents are Christians. They quote Bible verses talking about their man on the land, this and that, but they don't even understand these basic correlation of this document called the Constitution as it relates to sound foundational ancient principles. Now the people that most people hate so much are telling you this is a commandment. To whom? them. If one says that this Constitution is their instrument, and you run away from it because of that claim that it's their instrument, but you don't realize that it's a commandment for them to abide by, and you are the one that brings it to life. This Constitution does not bind you, it binds them. It's a commandment for them. And they're letting you know. So if you run away from it, there is no way you can command anything of them. That of the United States people speak of, it's all about commandment. You cannot command them of anything if you run away from these foundational principles. And if you pull these foundational principles called the Bill of Rights to yourself, and you're merely just using the words without comprehending the dynamics of what it is, you're still not able to compel any liability or performance. So what are the four factors? We just went over it. One is if the punishment is unusually severe. What makes it unusually severe? If there's a strong probability that is inflicted arbitrarily, meaning, remember we spoke about reasonable articulable suspicion and what probable cause really means? That's it right there. None of these commandments are isolated. It's a puzzle piece that fits together, meaning if you know what probable cause means, you'll be able to qualify what a cruel and unusual punishment is. Because if it's committed arbitrarily or inflicted arbitrarily towards you, then it is cruel and unusual punishment. So if they violate the 4th Amendment, automatically the 8th Amendment kicks in. Do you see how it all relates? And you see none of this is isolated. You must understand every one of them, because really, even though it says there are 10 bills of rights or 10 amendments, it's really all just one, expressing itself in different forms. A cruel or unusual punishment is that which is unusually severe if it is arbitrary. Again, cruel and unusual punishment. The first qualifying factor is if it is unusually severe. And what makes it unusually severe? If it is arbitrary, meaning it is not in accord to law. What law? The same Constitution that they're bound by. That serves as a commandment to them. And since all these qualifying factors of what cruel and unusual punishment means is interrelated, meaning you would have to prove that all four occurred, meaning you cannot isolate one cause out of the four substance of what cruel and unusual punishment means and say that's it, and because of that I've been inflicted cruel and unusual punishment. No, it does not work that way. It is interrelated, meaning all four are one. What is cruel and unusual punishment? That which is unusually severe. What determines what is unusually severe? It is done arbitrarily, meaning it is unlawful. The third factor is if it is substantially. Whenever you see the term substantial or substantially in any court document or any legalese, they're speaking about natural rights, natural law. That's what substantially means. It's the same thing. The third factor is if it is substantially rejected by contemporary society, meaning naturally speaking that ought not to have happened, aka equity. And if the fourth factor, and if there is no reason to believe that it serves any penal purpose, meaning now since it's not based on law, which makes it unusually severe, and it is not equitable, it serves no significant purpose to punish someone for a crime, meaning you must have first committed a crime. And if you don't commit the crime that they're bringing against you, then you have been inflicted cruel and unusual punishment. And in the case that you have been committed a crime, if the punishment is so severe that it does not match the supposition of crime, these days they're arresting 3-year-olds, throwing them in jail amongst grown men for things like throwing a temper tantrum. These things happen. They happen closer to you than you think. That is cruel and unusual punishment. Someone runs a red light, they throw them in jail 3 days, 19 days, 7 days. That punishment is not proportioned to any language of the law regarding the supposed traffic violation. They say you've done something wrong and they're keeping you in jail for months after month, and they're continuing the case saying, oh, well, we're waiting for whatever it is. That is cruel and unusual punishment, because there's no law that says that you can keep someone in jail for this long while you wait on a decision for something to happen. They say that you failed to identify, and because of that, they charged you with something and you had to deal with that court case for 9, 6 months, 2 years, 3 years. That is cruel, unusual punishment. They towed your vehicle so you have to walk on foot to go to the toll place and deal with one thing or the other. That is cruel, unusual punishment. You've clearly stipulated your own property as that, all caps, that you're presumed to be as a surety. Yet they're bringing a claim against you as though that's you. That is cruel and unusual punishment, presuming you know how to actually do it properly, beyond speculation of SPC, secure party creditor, or man in the land trash. And then it goes on and on. Your privacy. They're using your information against you to bring charges against you. That is cruel and unusual punishment. So even if you did actually commit something that's supposed to be a crime, if the language of the law regarding the punishment for that supposition of crime is not incremental to what they're actually doing, that is cruel and unusual punishment. If what they're doing is not based on law, then it's arbitrary and does not even apply in the first place, meaning they ought to have not even searched or arrested you in the first instant. That is cruel and unusual punishment. So in summary, the 4 qualifying factors that are interrelated, meaning they're not isolated, meaning you're not going to just pick one and say this is what it is. All 4 of them go hand in hand as one collective consciousness to qualify what cruel and unusual punishment means. And they are the fact that the punishment is unusually severe. How do you determine if it's unusually severe? If it's inflicted arbitrarily. How do you determine if it's inflicted arbitrarily? Based on the language of the law of what they're supposing you've done. And then based on that, you look into equity of what is substantially rejected by contemporary society. Is there a tortious act, aka tort, which we go over in the Patreon, which gives you a private right of action? Then it's cruel and unusual punishment. And even more so, regardless of whether you've actually committed a crime or not. It's the punishment, even to the crime that they're saying you've committed, based on the language of the law. Or have you even committed a crime in the first instance for them to even do anything to you? Those are the qualifying factors of what cruel and unusual punishment means, and is given to you in the judge-made law that everyone talks about so much, that makes common law, called Furman versus Georgia. You can find this in the Digital Library of Congress. Case number 69-5003. This is automatically self-admissible evidence right here. So you want to claim cruel and unusual punishment? Or you've yet to know that it even exists or applies to your circumstance? There it is. And those are examples. Are there more example instances? Yes, there are. Until next time, best of luck. A quick shout out to my patrons, and to those who have not yet joined my Patreon, I am inviting you, come on over. On the Patreon page, we speak about things that are not shown here on YouTube. We speak about the private side of the court, outside of just the finance. We speak about how to prove actual fraud and lift the corporate veil. In addition to some study tools, we speak about how to actually invoke private right of action there in the Bill of Rights. We speak about financial things with letters of credit, property rights, preservation of property rights. We speak about how to put your vehicle in a trust and how to not qualify for tax, how to properly fill out the GSA, public laws of the state and common law, how to establish probable cause. There are different types of damages. There's damage and there's damages. Those are 2 different things. The type of relief that you seek to be granted is a huge part of the type of damages. We go over that. We speak about the details of the bills of right, which is what you would really be invoking whenever you bring in any claim, whether on a financial level, private level, whatever it is. We speak about how to remain private when it comes to the EOSCAR algorithm and how to establish certain types of profile. We speak about how to go after bonds. We speak of how to get federal judges and other federal employees oath of office and bond. We speak about the different types of discharge and the specific ones, and we go over the details and more and more to come. Take care and best of luck.